Next on the agenda is Cathy Utz, and we, of course, of the Office of Children, Youth, and Families of the Department of Welfare. And unless, Madam Secretary, you have any other introductory remarks, the floor is yours.
Thank you. We're just going to short our
presentation and still get in what we need to.
Yeah. Well, that's, but again, unless I'm not seeing anybody who's saying, hey, wait a minute, I want to get to lunch, that we all came a long way we're getting into the meat of what we're here to do. So take what time you need, and we'll get out of here before the sun sets.
So I thought rather than go through all 51 slides, that I pulled out just a few, and rather than actually probably put them on the screen, I have a couple here that I was just going to hit pretty much the highlights, because I think that Mr. Sanders really has a lot of information that we all would be willing to hear and listen to. So I'd rather defer our time, because the department will be around. He's traveled so far. I think you probably want to hear him more than maybe you want to hear me. So what I would start with is kind of slide 3 really talks about the Office of Children, Youth, and Families, and a little bit about our structure organizationally. And it focuses on our Bureau of Child and Family Services. And we have 4 regional offices within that bureau who actually go out and license each of the county children and youth agencies. They license the private providers that deliver services on behalf of children and youth agencies, and that's only for placement services. We do not license providers of in-home service. We don't have that authority under the Public Welfare Code, so I wanted to make that distinction for members of the task force. It really is those placement providers that we have the licensing capacity over. Our regional offices each year license over close to 1,700 programs. And so within those 4 regional offices, they're doing that work with the staff that they have. And we have a license capacity for children in placement of over 15,000 places for them to reside. And in addition to doing the licensing and technical assistance work for the counties and providers, our regional offices also investigate reports of suspected child abuse when the alleged perpetrator is an agent of the county agency. So that would be a situation where perhaps it was a foster parent, it was a residential staff member, it was someone, maybe perhaps an employee of a county agency or a private provider. And so those investigations are done by our regional office staff as well. And in 2010, they did over 2,000 investigations themselves across the Commonwealth. Additionally, the regional offices also are responsible for conducting the child fatality and near fatality reviews that are required under Act 33. They do those reviews within 6 months. And they are also participating on each of the county Children and Youth Agency Act 33 review teams. They sit as members and they listen to the cases as they're being discussed within the county, and the county has 90 days to complete their reports on those cases. Additionally, our regional offices are really focusing on making a shift in looking at the quality of services that are being provided within our system. We recognize that we're responsible for the licensure and looking at making sure we meet regulatory compliance, but we've really begun to look at making sure that the services that we're delivering through counties and providers are of quality and they're actually providing better outcomes for children and families. And so in 2010, we started a quality service review process whereby each county within a phased-in period of time, probably over the next 5 to 8 years, we would be doing quality service reviews where we look at a core set of elements that really aren't looking at necessarily did you dot your I, did you cross, did you dot your I, did you cross your T, did you do a plan within the time frames, but really looking at those plans and saying, you know what, the plans are focused on really achieving outcomes for children and families moving forward. Moving away from really a paper-based process where we're just looking at records to really talking to families, talking to children, talking to providers, talking with the court to find out, do they all have a common vision for that family that they're providing services to? Are they functioning as a team to make sure that they're moving in the right direction? We are currently doing those reviews in 11 counties within the Commonwealth. This is our second year, and all the counties are really receptive that have been part of that process. And so what we're doing then as far as licensing is we're taking those same cases and we're applying certain pieces of our licensing regulations that focus really on the safety components and the health components, and then so it's an abbreviated licensing and really more focused on the quality pieces. So that's been something that we're extremely proud of. With the support of Casey Family Programs, we've been able to actually roll that out within Pennsylvania. And our focus is really on sustaining lasting change in counties and providers and within the Commonwealth, because we recognize that what we were doing in the past really wasn't having a lasting impact. Dr. Christian really talked about the cases that continue to come back to the system, and so really this provides us with the opportunity to be able to look and say, why do families continue to come back? What are we doing well within those families that are preventing them from coming back to our system, and then how can we take what we're learning about what we're not doing so well and really lead to systems improvement and lasting change. We also then have, on slide 6, we talk about the Bureau of Policy Programs and Operations, and that's the bureau that I actually am responsible for. And within that bureau, we have 2 or 3 divisions that are focused on development of policy from, child abuse and neglect up through adoption, and then the regulations that support that work. We also have the Division of Operations, and I think that folks are probably most familiar with that, in that that's where our state's child abuse hotline, Childline, is housed. And in 2010, we received over 1,222 calls to the hotline, and 40,000 of those were referred to counties as General Protective Services cases, and then 24,000 were referred to counties as child abuse cases. Additionally, we will get the calls that Ms. O'Connor talked about as well that are specific to cases where the perpetrator is not a perpetrator under the Child Protective Services law, and we refer those directly to the district attorneys in each county, and we provide a courtesy notification to the County Children and Youth Agency on those cases in the event that they may be familiar with that family or working with them for another reason. And we made over 3,000 referrals to law enforcement officials in the counties as well in 2010. Part of that responsibility really changed in 2006 with the passage of Act 179 that required not only Childline to take child abuse cases, but when it really changed to say that we would take all referrals on child abuse regardless of who the perpetrator was. And that's when we actually saw an increase in the number of calls that we were receiving at the state's child abuse hotline, because all the criminal matters were also coming to us as well. We also are responsible within the Division of Operations for all the child abuse clearances that are conducted. By statute, we're required to complete those within 14 days. And I get a notice each day about what day we're on. So like yesterday, we were completing them within 11 days, so that was kind of higher for us. But generally, we complete those clearances within a week. One of the things that I also wanted to point out is that in November, we had a significant increase in the number of calls to the state's child abuse hotline, particularly after the firing of Coach Paterno. And we had days where we had probably actually our rate increased by 110%. So we really struggled to answer the calls that day. We did, miss a lot of calls, but we put a plan in place where we met on a daily basis to talk about the number of calls that we were receiving, what we were going to do. We had to mandate overtime for our staff. We have 39 caseworkers who take calls on the child abuse hotline, and then we have supervisors, obviously, who supervise their staff. They were also taking child abuse calls, And we had a plan whereby if we had gotten to where we were missing 9% of our calls on a daily basis, that we actually had staff within our policy division who were going to begin to take child abuse calls. I'm happy to say that we've actually decreased, and we're running probably about 5% right now in the number of calls that we're missing, so that's down from where we had been. One of the things that we've been doing is we look kind of like hour by hour in when we were getting calls, and we were trying to predict a pattern to say, is it first thing in the morning? Was it right after lunch when professionals came back? Was it at the end of the day? And just when we thought we had a pattern in place, something would come and it would change. And so we found that it was really just caught all over the board. And if we began to plan for calls maybe at 9 o'clock in the morning, then they'd start to come at 1 o'clock. And so we really paid attention now and tried to do the best that we could to figure out how we manned that. We did have staff that were coming in, and we had changed some shifts around. So we continue to do that. I meet with our Childline supervisors every other week right now. We're talking about what we need to do and how we can actually make some systems changes to decrease that. Our threshold of where we would like to be is no more than 6% of our calls are dropped each day. We do see, I think, the same thing that the county's experienced, that if we are having staff vacancies, then we struggle more so than when we have our full complement of staff. We currently have one vacancy for a Childline caseworker right now that we're hoping to fill in the next few weeks. So. Yes.
Just a quick question. So that 100% in increased calls, was that 100% of calls because of additional concerns of child abuse, or were it people who were just yelling at you?
It was a combination of both. We did get some calls about how we were the kind of the worst state in the nation and how could we let this happen. So we did receive a fair share of those. But then we're really liking it to that after Coach Paterno was fired, I think that we saw that increase because people thought that while he may have followed what was in statute, that he was fired because he morally perhaps didn't do what folks thought that he should do. And so there was a kind of a public cry. I think that people were afraid that that might happen to them. And so we did see a spike, and then that has since declined, and we're back to kind of our normal level. We're also then responsible for the operation of the Interstate Compact for children. So any child who leaves Pennsylvania or comes into Pennsylvania for placement purposes within the child welfare or juvenile justice comes through our division of operations as well. And then we're also responsible for overseeing all the grants and contracts to counties. So our role is we actually do provide services to the Commonwealth's constituents, but we also really function more in an oversight capacity for counties and private agencies. I did mention, and I have slides in here that talk about the definition of who a mandated reporter is on slide 25 and 26, both before Act 179 and then after Act 179, because it really changed not necessarily what was reported, but when it was reported. Because in the past, it was you had to have a reasonable cause to suspect that a child coming before you, so the child physically had to be before the mandated reporter in order for them to actually cause that report to be made. And Act 179 then changed that and said that it had to be a child who was under the care, guidance, supervision, or training of an agency. And so no longer did the child just have to come before them, but they could hear information third hand, and if they had reasonable cause to suspect based upon that information, then they were mandated to report to us. I also included in slide 27 and 28 additional reporting requirements for mandated reporters that you can take a look at, because I know that is part of the focus of the task force. On slide 32, we really talk about the federal outcomes and measures that we're held to and the things that the federal government looks at when they come in and do their child and family services review for us. And they are obviously that children are first and foremost protected from abuse and neglect, and that they're maintained within their own homes safely whenever appropriate. that they really have permanency in their lives, that when they come into the child welfare system, that we do everything that we can to get them home in a quick manner, and if we can't, then that we find permanency for them in another way. And that we're also looking then at their well-being outcomes, so making sure that they have their educational and physical and behavioral health care needs met. Some of the strengths that I wanted to talk about from our Child and Family Services review that focus on safety really relate to the timely response to reports that county children and youth agencies and the regional offices were getting out to families in a timely manner once they received the report. Lori talked about some of the time frames earlier. That many of the counties had expedited responses for children who were younger, and that we had a strong array of services to meet child and family needs, and that we completed risk and safety assessments on a regular basis, and that we had a low recurrence of maltreatment. Some of the safety concerns were related to if we had a case that started out as a general protective services case, but over the course of time, it may have ended up being a child protective services case or a child abuse case. We weren't always as quick in transferring that case from a CPS to a GPS as we should have been. That the number of reports of children who were abused in out-of-home placements was concerning. And that while we were doing risk and safety assessments in a timely manner, that they were focused primarily on looking at presenting problems rather than underlying issues. And so we believe that that likely would lead to those recurrence in those GPS reports continuing to come back. So our focus really has been now on looking at finding better ways to address those underlying issues. As a result of the Child and Family Services review, we had to complete a program improvement plan. And it was really focused on child, youth, and family engagement and case planning, because we've talked about some of the family engagement strategies that we're employing, and we believe that if we do better family engagement from the start, that then families will be able to respond more appropriately to services and become healthier as we go along. We need to focus in ensuring that we're providing timely permanence to children, particularly children who were going through the adoption process. It was taking us a long time to have children who did have a goal of adoption to actually then have them adoption. Once the parental rights were terminated, we did a good job of making sure that the adoption was finalized, but it took us a long time from the point in time where the goal was changed to actually get to that point. And then I briefly talked about sustaining change. And the last slide that you have, slide 48, is really focused on our process for driving sustaining change. We had a Child and Family Services review in 2002, and then we had another one in 2008. And what we found was that many of the things that were noted as areas of concern in 2002 remained the same areas of concern in 2008. And we took a look at the program improvement plan that we had developed as a result of that 2002 review, and it was really a compliance and task-focused plan that said we would issue policy, we would do certain things, but that it really wasn't focused on making the change at the local level. And so we worked with, through our partners with Cathy Family Programs and the American Public Human Services Association, to adopt a model of really defining where we want to go as a system, and we're doing this in each of those 11 counties where we're doing the quality services review, assessing where we are, developing a plan that provides us a roadmap for how we're going to overcome our current barriers and challenges, implementing obviously those plans, and then monitoring those through the quality service reviews that I mentioned earlier. And then we start the process over so that it's a circular process rather than a linear process, which many of our efforts have been to date. So with that, I hope that was a brief overview for you.
Cathy, can you talk to us a little bit more and define for us what a missed call is in Childline, but also you mentioned drop call.
Yeah.
So is there a difference?
So we categorize two different types of calls. We have abandoned calls, where a person will call, they will get into the queue so that they will be kind of on hold, and then they terminate the call on their end. And then we have missed calls where the person never gets into our queue, so they never ring. We know the number of calls that people are calling, but they are totally dropped. They never get to even in the queue.
Is that because our capacity to handle those calls, so we just have way too many in the queue at certain times, and so we never get to them?
Yes.
Okay.
Could we turn to page 28, please, of your slides, which you didn't highlight, but I think we might want to spend just a minute or two discussing?
Certainly.
Because it's the reporting with institutions part of reporting laws. And I think that, I think there was some concern kind of in the Penn State situation where individuals were reporting up and then other, and then obviously the whole system collapsed. And I assume that people would want to look at that part of the law, although I will say coming from a hospital system where we think we have a decent system for reporting, if you were to mandate that every person in this institution who knew of a possible child abuse case was mandated to report, you would get, at Children's Hospital of Philadelphia, potentially 45 calls about the same child.
Yes.
Because so many people touch that child at the hospital. So could you just review this part with us, and if you have any suggestions for kind of where this, you think this might best live, or how it should work? Thanks.
Yeah, I can review it for you. What this really says is that within an institution or a school, that each of the schools or institutions has to have a process in place whereby they determine how the report gets made to Childline. So that if it is a teacher or perhaps a nurse, there's one generally central point of contact for teachers, nurses in institutions that they will talk to, who then is responsible to make the report. And so I think that, Dr. Christian's correct when she says that it seems like it's a good process because you have one central point of contact. We're not going to then get, numerous calls on the same call. I think we've seen also the converse, where there have been situations where folks didn't make a call. You have a mandated reporter, a teacher, or someone who really thought and had concerns, and they may have let their principal know, and then the report didn't get made because the principal may have said, well, I don't know that it happened, or they didn't talk to the child. So I think that there's pros and cons probably to both, and I think it would warrant, a further analysis and walkthrough of what those pros and cons for be, because I think that it could, work in either way, and I've seen both sides. We've had a lot of folks who then have been concerned, mandated reporters who will come to us and say, I'm concerned. They may not have a closure loop that initial mandated reporter who saw the child, that they may never know within their institution whether the report was actually made. And we hear from them that they want to make sure that they're fulfilling their duty and that they're fulfilling their responsibility, so they go ahead and make the call. I think some of the increases that we actually saw in November, some of those were related to a mandated reporter who made it within their institution, and they said, I'm calling anyway. And so I think that there are, policies and procedures in place. I think some may fear retaliation if they don't know that their principal made the call and they make a call anyway, even though the statute very clearly says you can't have retaliation in those situations. So I think there's probably pros and cons to the way that it is.
Okay, and then I have one other question, then I'll turn over. When in the CFSRs where we have strengths that include repeat maltreatment was low, part of my concern is that our GPS system is not counted.
Correct.
Right? So, and I think everyone on this task force needs to understand that if you look at state-by-state statistics, Pennsylvania looks like the, as I always say, the kindest and gentlest state.
Yes.
Because we have maybe 1/10 of the child maltreatment as any other state, because GPS doesn't get counted.
Absolutely.
And so when we say repeat maltreatment was low, could you define that? Because I think it really refers to maybe CPS and re-CPS reports. And again, it kind of goes to like how these two systems work or don't work together.
Yeah, and I think that's exactly what it is, that Dr. Christian, it includes only CPS cases. It does not include GPS cases. And as Ms. O'Connor, talked about earlier, currently we do not have a statewide system that gives us that data. Because I must tell you, I came to the department 13 years ago, and one of the first questions I asked was how many children start out as GPS cases and how many of them end up becoming CPS children. And we couldn't answer that question. So it's been a question that I've been wanting to answer for 13 years. And we're well on our way to actually having a system. Ms. O'Connor talked a little bit earlier about how we spent the last 2 to 3 years really trying to make sure that every county children and youth agency had a system in place, and that our eventual plan is that we will take the information from each of those systems and put that into one statewide system, and that we'll be able to get information. We just talked with a county earlier this week who was working on their system, and they can do some of the things, and they were talking about these orange cards, and they talked about how they're just moving to an electronic system, and they had orange index cards. And that's where they kept most of the information, that was key on their families, and everybody talked about the orange card, and they went back to it. So, I think it's pretty concerning that in 2012, with a state the size of Pennsylvania, that we don't have an electronic record for a child welfare system, but we're on our way.
Okay. Thank you.
Ms. Hutz, again, thank you for what you do. I've known you for a long time. I have 3 questions. Who can access the Childline database for clearance purposes? So, in other words, is there somebody that's other than a DPW employee that can access Childline to check for a clearance?
No, because the information, the Child Protective Services law requires that information is confidential. It can't be accessed by the public. So that right now we have a paper-based process where an individual, an applicant, submits their request for a clearance to us on paper, and we send it back to them. Because you can only exchange information with certain individuals, and so we just can't go out, and it's different than the crimes, because the crimes are public information, and therefore you can access those usually through AOPC's website or the state police website. But we're not permitted to do that because that information is confidential.
Follow up to that. So law enforcement can't tap into Childline database?
They cannot.
Is there a fee associated with that screening process to the individual seeking a clearance?
Yeah, the child abuse clearance, for the department's child abuse clearance, it's $10. There's also a state police clearance that folks, if they're getting employment, have to pay, and that's $10 as well. And then there's an FBI clearance that we do electronically, and that's approximately between $35 and $40.
When calls come into Childline, is there a process by which those calls, incoming calls, somehow are prioritized, in particular for those that are characterized as mandated reporters? In other words, if Dr. Christian were to call in, would her call be received perhaps before my call? In other words, is there as it should be.
Anything for Dr. Christian. We've known her for a long time, too. No, we don't know who's calling, up until the point in time where we say, hello, Childline, and they tell us who they are. So there's really not a mechanism for us to be able to do that unless we had caller ID with everybody's names, and we would know that it was Dr. Christian calling, not you, and then we would take her call first. Yeah. But no, we really don't have the capacity to be able to do that until you know who's on the other end of the call. One of the things that we've been trying to do is everybody calls the hotline because that's the number they know. So they call that number if they want to, have a question about their child abuse appeal. They call that number if they have a question about their clearance. But we do have other phone lines that are dedicated to taking those calls. And so we just recently were able to include in our system if you're calling to report child abuse, press 1. If you're calling for a clearance, press 2. If you're calling for something, an appeal, press 3. And so that we were able to actually implement that, to be able to dedicate our resources that are actually taking the child abuse calls to that and diverting others to the staff that handle the appeals. But that's the number that everybody knows.
And then my last question, just to talk about the way mandated reporters, as I understand, the initial requirement is an oral report. Am I also correct to understand within 24 or 48 business hours there needs to be a written report that's logged by the mandated reporter?
Right. So there's a requirement in the statute and regulation that says within 48 hours of the oral report that the mandated reporter has to submit the written report, the CY-47 as it's called, to Childline, and then we send that to the counties as well.
And then when the investigation is ultimately concluded, am I also correct to understand that that mandated reporter is to know the outcome of the status of the outcome, whether it's indicated or founded,
Yes.
or unfounded rather, indicated or unfounded, that is communicated to that mandated reporter? That
It's not communicated on a consistent basis by counties, but that, yes, there is the statute does permit a mandated reporter at the conclusion of the investigation to get the status determination as well as whether any services were provided. Did you have another question?
It just occurred to me that, like, if you wanted a triaging system within phone calls to Childline, you can repeat your press button 1 if you are from a doctor's office or a hospital, press button 2 if you are this or that. You know, so since you have the capability, you could just do another round.
Thank you.
You're welcome.
Yes.
I've earned my lunch.
Hello, you did a great job.
Thank
and I
you.
just have a couple questions about Childline.
Sure.
I read in some of the materials that there is a Senate bill that's being proposed to upgrade the phone system that you currently are using. What is the status of that? If you don't know, maybe staff can
do know.
find out.
We actually work with our Bureau of Information Services on the upgrade, and we were just told that that was put on hold. Again, because we're looking to do something a little bit different, and I think it goes into the procurement process. So right now it's been on hold.
And so the type of thing that you're considering doing differently, would it be more computerized so that paperwork would go faster to the counties or to law enforcement? Yes. So it's more of a comprehensive overhaul than just changing the phone system?
Absolutely.
Is that fair?
Yeah, one of the things that we want to really be able to do is transmit the reports of suspected child abuse electronically back and forth between the department and the counties, so that it provides, less duplication of effort for us as well as for counties. Because what happens now is we may have, particularly in some of the larger counties, we may have 3, 4, or more reports. And what we'll end up doing is we'll call them and we'll spend perhaps sometimes a half hour actually calling them to talk about each of those reports, depending upon the number. So having the ability to transmit that securely between the department and each of the counties would, I think, save us time as well as save counties time as well. And we would build in an alert, obviously, that said you received a new report from Childline. It would also give us then the opportunity and the ability to be able to track those GPS cases over time, and as Ms. O'Connor mentioned, for counties to be able to see records of families who have moved across county lines, which we believe is critical as well.
And so if your project is on hold, is there a time frame that has been given to you in terms of when it would be anticipated to be implemented, or is it on hold from your end because it's so comprehensive, or is it on hold from a funding end?
No, it's just the phone system upgrade that is on hold.
Okay.
Our IT and our larger child welfare information technology strategy is not on hold, and we're progressing with that.
And then as far as the caseworkers that actually handle these calls, do they also have bachelor's degrees?
They do.
Okay. And are they mandated to go to any sort of trainings on a regular basis, or can you just tell me a little bit about who they are or what they do?
Sure. Many of the caseworkers who work at Childline likely have come from other county children and youth agencies, and they come to the state because we were paying more than some of the counties were paying, so that they came to the state from counties. So they came to us with, a certain level of experience already. We also get staff who are current state employees who are transferring within the state. Commonwealth system. We do have a training period for each of them before they go on the hotline. So we do, and it's approximately 3 weeks where we sit down and we do just on-the-job training where we talk to them about roles and responsibilities, what the child welfare system is about, what they need to do. And then they actually are paired with a supervisor. And the supervisor will take the Childline calls, and they will listen to the supervisor, interact with the caller, and then it's a point in time where that will then flip, and the caseworker will begin to take the calls with the supervisor there continuing to manage. And so once we feel comfortable and the supervisor believes that the worker, is asking the questions, and we have a standard set of questions that we're, asking for on each call. And once the supervisor feels that they're comfortable with the worker and the skills that they've progressed, then we will put them on the hotline alone.
Okay, great. Thank you.
You're welcome. Thank you.
Mr. Chairman, it just occurred to me, and I don't know if you can answer this, Cathy. I think you can. Is there a mechanism once the county or DPW receives the initial referral of suspected child abuse to begin the investigation? Is there a mechanism that goes out to potential employers of the alleged perpetrator? And I know this is not about the Sandusky debacle, but and this is much bigger. But are there notices that go out to in those situations where the alleged perpetrator is engaged, and where the alleged perpetrator is engaged with children on a regular basis? Is there anything that happens there?
So I'd answer that in two ways. If the alleged perpetrator, it's a child abuse case where a person works in a child care setting and they have allegedly abused their own child, we are not permitted by statute currently to notify the employer of a pending investigation, nor can we let them know at the end any of the results. Where we are permitted to have a conversation is when the person who is alleged to be the perpetrator, if they are working in a child care service, that child care service has to then have a safety plan in place for how they're going to assure the safety of not only the victim child, but also all of the other children in their program. So in that situation where the abuse allegedly occurred in a foster home, in a residential program, they would be aware of it in those situations, but not if it was an employee who allegedly abused their own child.
If I could just to follow up, if the referral comes in, maybe the individual works in two different settings. The allegation is the perpetrator committed an alleged incident of child abuse on a child within setting number A, employment number A, letter A, but also that individual happens to be engaged in setting number B, which also is engaged with children. Is there a way to reference and notify agency or entity number letter B?
No, we would be able to work with agency A, but we are not permitted to notify agency B.
Judge Grimm, any questions for us?
No, thank you, Mr. Chairman.
All right, thank you. Thank you very much for your abbreviated but very helpful presentation. And, of course, we have your whole packet of materials of each of the panel does.